Hello everyone, it's James Bremen from Quinn Emanuel. I hope you're well. Thank you very much for taking the time to watch these short video vignettes on CV19 issues. Longer versions are going to be posted on the Quinn Emanuel website, and we also intend to produce for you a short note on each of the issues as they are produced on a webinar. But this is intended really just to give you a quick look on some of the key issues that I think are going to be consuming some of your working days in the coming months. And if, like me, you're sitting at home Googling how to cut your own hair, which is truly frightening, I hope that this is a slightly more productive use of your time. This first section, I'm going to talk very briefly about force majeure. Now, in January of this year, I started receiving force majeure claims from clients where clients were receiving these notices, principally from Chinese contractors and suppliers of Chinese goods who were claiming that CV19 had the consequence that they were unable to perform. Principally, that was about getting things out of China. Now, there are an increasing number of these force majeure claims being made as the pandemic spreads across the world and impedes performance, and we'll come to that in a moment. But it is, in fact, an area which is very often misunderstood, and so I'm hoping to put some of those things right in this very short chat. Though the first thing to understand is that under English law, and in these sessions I'm going to talk about English law principally, but many of these things apply to common law systems as well, and in other specific sections I'm going to talk about some Middle Eastern legal systems, and I'm going to talk a little bit about Asian legal systems as well, because we're confronting these issues daily, globally, actually, in lots and lots of different jurisdictions. But under English law, force majeure is not a cause of action. Force majeure is not something that I can claim from you unless the contract between us actually has a force majeure provision in it. So that's the place to start if you get such a notice. Does the contract contain a force majeure clause? And if it doesn't, no claim is available. There are other things that might be available, but certainly not force majeure. And when we look at the force majeure clause, many of these clauses are boilerplate clauses that frankly have not been looked at in years. And there's an interesting debate about some of the standard forms that we're going to do in later sessions, or talk about briefly in later sessions, about whether an epidemic is a pandemic. Now, it's a theoretical legal argument, but there is a sort of a linguistic difference in the two things, and whether relief is properly available in those circumstances. But let's say you get a force majeure notice from a counterparty. What does that mean? Well, the first place you do is you have a look at the force majeure notice itself. Does it identify what the claim is? And of course, we're going to see that process. Most force majeure clauses provide for a notice, an ability to stop work for a period of time, and then either party, after the expiry of that period of time, has the capacity to terminate the contract. Now, this termination is coming up. We haven't actually seen many of those. Indeed, I've not seen any of them yet. But in coming weeks, I will, because a number of these will be coming to fruition and they create different issues. But the force majeure notices that are issued to you are going to be notices which need to set out and comply with the contract. Does the force majeure provision in your contract provide for the specific relief that the contractor is claiming? And what does that really mean? Does it mean that they are saying CV19 itself is an exceptional circumstance, and that must be right, and my obligations to perform to you are in fact impeded by CV19 itself, and I need to demonstrate a few things in order to make that good? The first thing I need to demonstrate is that CV19 is contemplated by the clause, and that will be a question of looking at the clause and seeing whether it's addressed. The second thing I need to show is, what did CV19 mean for me and my ability to perform my obligations to you specifically? Now, in order for a successful force majeure claim to be made in relation to CV19 as a general principle, we need to show causation between the thing complained of and your obligation to me under the contract. So I can't do the thing I promised to do for you because of CV19. And what does that mean? Well, it again is a question of drafting, and that's of course where you must start. But really, what it means is I got sick, my workforce got sick, we were unable to continue as a result of that, or something along those lines? Did the virus itself have the consequence of causing the failure to perform? And if that is, that's very unfortunate. But you then take a next step and you say, well, did it mean that you could not perform any of your obligations to me? Or did it mean that you could only not perform part of your obligations to me? A part of your facility was impacted by this virus and you had to close it, but the other parts of your facilities were working. And so we can see partial force majeures generally, and that is not an uncommon thing that we do, in fact, see. So partial force majeure, complete force majeure, we need to show causation with the CV19 epidemic or pandemic now, and that was the true cause of the inability to perform. Most of the time, in fact, that's just not true, and I'll come to that in a moment. But if you've got that situation and you receive a notice, then the natural question is, what did you do to mitigate that? Because most of these provisions require the exceptional circumstance to be one that the other party did everything, either in their reasonable endeavours or their best endeavours, to overcome. So did they mitigate this? Did they, when their first worker at their camp on a site got ill, did they quarantine that person? Or did they do nothing? Did they do nothing at all, allowing the disease to spread? Well, that creates a whole lot of issues. We're going to be talking in other sessions about tortious claims, claims of negligence, and class actions, which might actually come out of the way in which people are responding to this virus. But if you look at the steps, the force majeure clause will generally require a party making a claim to identify it in a notice, and we've got a section coming up on notices in a future chat. What happened? It was exceptional. It impacted me. How did it itself stop me from actually doing the thing which I was supposed to do for you? It's not a general excuse not to perform. And what did I do to mitigate that? Those are the steps. That's what you need to do. And that's what you need to do when you're looking at the notice. And the notice, of course, is only available in circumstances where it's a contractual remedy. It's not something which a contractor can just claim for as a function of, well, economic hardship, which is a civil law doctrine. We're going to do another one of these little chats about that. Actually properly construed even in French and civil law, French and German law, for example, it's not the case that economic hardship could possibly apply to CV19, but those claims are also being made. But what are these claims really about? So you get a force majeure claim, or you're considering making it, and you look at that claim, you'll form a view as to whether or not the thing was truly caused by CV19, or was it caused by something else? Invariably, the answer to that is yes, it was caused by something else. Most circumstances that I'm looking at are caused by governmental action. It's rare that entire workforces are brought down by this virus, but what brings them down is either the company taking a decision to stand down their workforce, which has happened, or the government mandating that be done, or mandating that certain things can't be done. And we've got to think about what that all means. If it's a government action, then does it properly sit within change in law provisions? And we're going to have a chat about that in another one of these webinars. Or is it the case that it's not a change in law? It makes the activity illegal. Do we then have to look at severability provisions? And what does that mean? And we'll do another session on that, or the doctrine of impossibility. Do we have to deal with that as an English law concept? If the thing is now impossible to do, what does that mean? So there are an awful lot of other potential bases upon which force majeure clauses can be, or force majeure claims can actually come to fruition, and we'll deal with them as they arise. But what we've seen is initially claims being made as a force majeure, and then as government actions changed, has arisen or followed, new notices are coming in, recharacterising the claims from the moment of the governmental intervention. Now, those interventions, of course, are right. I'm not saying they're not right. They are absolutely right, and they are necessary. But what that means is actually very difficult to fathom, because as we look at the changing legislative environment everywhere, I worry, for example, that there is legislation in some jurisdictions that now looks at impeding a party's capacity to enforce security. Now, that's fine for domestics, people both within the same jurisdiction, but international counterparties may have valid treaty claims against governments for doing that. There's a lot of very fast-moving pieces on this chessboard at the moment.